Hello friends, I am Sivaraman Reddy. At the outset, let me wish you all a happy Independence Day. Independence Day is one of such occasions where we can take stock of the situation, state of affairs, where the country is heading to, and what the forefathers of our country had dreamt of while this country was formed. So this gives us an opportunity to look back into what we have done and how we are progressing, whether our progress is in alignment with the constitutional goals of this country, or did we err, or did we deviate anywhere along the path. So I think that I can just try to throw some light on the happenings in the independent India, particularly because we are now entering into 75th year of Independence Day. Certainly, we need to take a look at what is the situation now, and how it has panned out, and from where we have started, and from where we have reached. I would like to briefly touch upon the landmarks in the development and the history of the law making in this country, so that this perspective can give you an opportunity to just relate to the facts. Friends, you all know that India has got one of the robust constitutions in the world. This is one of the written constitutions, a mammoth document, about 395 articles, 8 schedules when it was originally founded. So gives us what we call, it touches upon all the aspects of governance and preserving, protecting the culture, religious rights and the fundamental rights, and also a clear-cut policy is given, keeping the welfare of the citizens as to how the constitution has to what we call move forward with these goals and objectives. Let's take a look at the Indian constitution as such, friends. So you all know that prior to the Constitution of India came into being on the January 26, 1950, we had Government of India Act 1935, which was of course passed in the British Parliament, and that didn't give even voting rights to all citizens. So it was a restricted constitution, but nonetheless it was what we call a basis upon which our constitution was founded. About 3 years has been spent on developing the constitution, deliberating over each and every article, each and every amendment has been clearly debated, discussed with the common goals and the shared goals that the founders of constitution had in their mind. So therefore, if you look at the Constituent Assembly debates, so we had such wonderful list of what we call famous people who had contributed to our constitution. So starting from the freedom fighters like the Pandit Jawaharlal Nehru, Kalam Azad, Krishnamachari, C.D. Deshmukh, then Durgabai Deshmukh was also there from Telugu lands. Then we have really stalwarts over Sardar Vallabhbhai Patel, Babu Rajendra Prasad. So the names are really what we call very, very illustrious names were there, and they have put in all their life and all their efforts and all their passion into giving us a document, a written document as to how the India should progress once what we call it is freed from the clutches of the British. We were freed from the yoke of British and given independence to ourselves, so we can govern ourselves. So keeping those ideals in their mind, so they have drafted a wonderful constitution. Dr. Baba Saheb Ambedkar was the chairman of the drafting committee. After the entire constitution has been written, then the question of inserting the preamble came into light. So the preamble is, of course, it is the beginning of the constitution, but preamble was written after the entire constitution has been drafted, taking the fundamental features of the constitution, and all those ideas have been embodied in the preamble. So the preamble reads like this: we, the people of India, having resolved to form yourself into a socialist democratic republic, and it has also guaranteed the rights like liberty, equality, um, fraternity. So all these are all very great ideals. Okay, so they thought that this is the guiding force that would define the Indian Constitution. That's how Indian Constitution came into being. Then, once the Constitution has been adopted on January 6, 1950, which we all celebrate even today as the Republic Day. Recently, we have celebrated 72nd Republic Day. Then the real started what we call the amendments to the Constitution started coming into picture, taking into consideration the needs of the society, the needs of the evolving society as such. So the first Amendment Act, which came in 1951, was basically came into being on the demand of the agrarian reforms, because in those days most of the land was in the hands of the Jamindars, Rajas and other people, and if the government wanted to distribute those lands in order to achieve an egalitarian society, welfare to all people, then those Jamindars and leaders were opposing to that. So therefore what the government has done was they have put all the laws pertaining to these land reforms into a new schedule called Ninth Schedule. So the Ninth Schedule came into being by amending Article 31B. So the importance of Ninth Schedule is that any law that is being kept in Ninth Schedule of the Constitution of India cannot be called in question in any court of law on the ground that it is taking away or it is violating the fundamental rights of the citizens. So therefore it was a first blow to the citizens of this country, given the promise of the Constitution, because between 1935 Government of India Act and our own Constitution, the basic difference was that in the 1935 Government of India Act there was no chapter on fundamental rights and direct principles of state policy, but the uniqueness of our Constitution is that the fundamental rights have been incorporated in Part 3 of the Constitution of India, and then the basic document of governance in the form of directive principles of state policy was given in Part 4 of the Constitution. So first this First Amendment has taken away the fundamental rights of the people whenever any agrarian related issues were infringing on the fundamental rights, and because these things cannot be questioned in a court of law. This First Amendment Act was challenged in Shankari Prasad Dev versus State of Bihar in 1952, and wherein the Supreme Court has ruled that all laws put in Ninth Schedule cannot be questioned in for violation of fundamental rights. Therefore, the First Amendment was made valid. From there onwards, the infringement of fundamental rights has started. Then came in 1964 in the famous case of Shankari Prasad Sajjan Singh versus State of Rajasthan, wherein again the agrarian reforms were the question, and it has what we call affirmed whatever that was affirmed in the Shankari Prasad case. Then with regard to amendment of Constitution, one of the important and landmark judgments in this country is the S.C. Golaknath case, S.C. Golaknath versus State of Punjab in 1967. It was a 11-judge judgment, and wherein 6 judges favored the majority rule, which says that the fundamental rights cannot be altered, cannot be tinkered with, they cannot be amended by amending the Constitution of India. So that was a great relief. So that has taken a diametrically opposite direction prior to the judgments in Shankari Prasad as well as Sajjan Singh cases. So I.C. Golaknath case was really a landmark judgment in this country, which has protected the fundamental rights of the citizens. But next, after that, now the famous celebrated judgment is His Holiness Keshavananda Bharati Sri Pada Swamigal Varu versus State of Kerala, wherein the I.C. Golaknath case was overruled. And in that case, in that judgment, the Supreme Court held that Article 368, which gives the amending power of the Constitution to the Parliament, uh, can what we call amend fundamental rights, but such amendment shall not alter the basic structure of the Constitution. So the test of basic structure was come into force via the Keshavananda Bharati judgment. So it was a 13 judge bench wherein 7 judges upheld the majority judgment, whereas 6 judges dissented. The judgment was pronounced on 23 April 1973. This date is very important because any law made in this country after 23 April 1973, that is after the pronouncement of Keshavananda Bharati judgment, any law made after that shall have to pass the test of basic structure of the Constitution. So what is this basic structure? So basic structure has got a few salient features, like that democracy is a basic structure, socialist, secular, democratic. Okay, that's the form of government. All these areas: socialist, secular, democratic. Then equality, fraternity. Those things that we have mentioned in the preamble, and supremacy of the Constitution. So these are all what we call, they have been evolving, still they are evolving. So at least some 18 to 20 features have been identified as basic structure of the Constitution. So if any law made by the Parliament or the state legislatures violates the basic structure, then it can be struck down. It is made null and void. So that's a landmark judgment in the history of our India's journey from 1947 onwards. Some of the important cases that had shaped the course of this country include the famous cases of, like, say, Srimati Indira Gandhi versus Rajnarayan case in 1975, then Srimati Maneka Gandhi versus Union of India, where freedom to move anywhere she wanted to. So that has come into question, and the Parliament, Supreme Court held that freedoms guaranteed and that part of the Constitution cannot be violated. Then we have got another important case like Minerva Mills. Okay, so Minerva Mills also established certain things, and it is a landmark judgment. It has added a clause to Article 15(4) and also another article. Okay, so Minerva Mills case is also very important. Then, if you look at other important cases that has shaped the destiny of this country, include the S.P. Gupta versus Union of India case. So S.P. Gupta case came into question the transfer of judges. So whether who can transfer the judges, whether the Minister of Law can transfer the judges, or how the appointments are to be made and all that. So this is a very landmark judgment so far as guiding the judiciary and judicial appointments and other things. Then second judges came in 1992 in the case of Supreme Court Advocates on Record Association versus Union of India, which is also called the second judges case. This is also very prominent in the sense that the collegium, appointment of judges through collegium, has been laid down in this judgment. Then in 1999, another third judges case came, and the fourth judges was the NJAC case in 2014, National Judicial Appointments Committee. So that was also struck down. Okay. With regard to judiciary, these are the important cases. So in the 90s, we have got a very famous case of S.R. Bommai versus Union of India, wherein it was held that how to decide the majority of a elected body in the assembly, either in the parliament or in the legislative houses. So what is the test? So in the S.R. Bommai case, it was decided that floor test, majority, deciding the majority in the floor of the house is the only criteria to decide whether a particular government of the day enjoys majority in that particular house or not. So the floor test has come into vogue via the S.R. Bommai case. Then uh, other cases like very important cases. For example, when we look at the reviews, okay, appeals, reviews, and all those things in the superior courts, curative petitions. Okay, the concept of curative petition has come only through the judgment in Rupa Ashok Hurra versus Ashok Hurra in 2002, wherein it said that after a judgment has reached the finality, even if still the petitioner wanted further appeal on that, no appeal can be entertained. But if there is any error apparent or if there are any grave mistakes in the judgment, they can be cured or they can be rectified by filing a review petition. And afterwards, even after review also still there are some mistakes in the judgment, they can be corrected, they can be set right by way of a curative petition. So curative petition is also a very, very important development and landmark development in this country. Then we have also got down the line bank nationalization case in 1971, R.C. Cooper versus Union of India. Then abolition of privy purses, of course, that is also a very important aspect, very important judgment in this country. Madhava Sindhya versus Union of India. So in that case, the cancellation or the cancellation of privy purses has been challenged in that case, but government upheld that, and that has been continuing, and privy purses have been abolished. Okay. So these are a few cases that come to my mind, and we can also discuss about other important aspects like very recent judgments. If you take into consideration, right to privacy is one of the important landmark judgments in this country. Right to privacy has been made a fundamental right under Article 21 through the judgment pronounced in the case of K.S. Puttaswamy which is Union of India. In that they said that citizens have got a right to privacy. So privacy is a very, very important aspect, and it has been made a fundamental right. Then we have also got various other landmark judgments. Very recently we have got this GST, of course, is also amendment to Constitution of 101 amendment brought in GST into the country. Then the cooperative societies, okay, the cooperative societies, multi-state cooperative societies and state cooperative societies, that constitutional amendment has been challenged in the Supreme Court, whereas the Supreme Court struck down that part which failed to get the majority of the states' concurrence for the amendments in the cooperative acts. So therefore, so far as multi-state cooperatives are concerned, that was struck down, but states can still have their say in the formation, development and amendment and repeating and all those things related to the cooperative societies as such. Then the reservation case is also very, very important. So reservation plays an important role in the society. So if you look at reservation cases, after this Mandal Commission, this thing, Indira Sani versus Union of India case, a very, very important case, wherein it has said that creamy layer has brought into the picture, and how to, what we call, decide who is backward, and very whatever guidelines have been given in that. So Indira Sani versus Union of India case is also very, very important. Then Nagaraja versus Union of India, Balaji versus Union of India. So these are the important cases as far as reservations are concerned. Then if you look at the education sector, TMFI, so this is again a 13-bench judgment. TMFI versus State of Karnataka. Okay. So in that it was very clearly mentioned that minority institutions, if they are getting aid, they have to follow the rules prescribed by the government, and they have to provide reservations for the required categories as per the government policies. But so far as unaided minority education institution concerned, state has no role in those colleges, and they can have their own methods of admitting the students. So Constitution Article 29 Clause 2 and Article 31 were discussed in TMA-FOI, and the scope and the applicability of the TMA-FOI case has also been very neatly discussed in PA Inamdar versus State of Maharashtra, PA Inamdar. So PA Inamdar case elucidates the decisions given in the TMA-FOI case. So TMA-FOI case, they have raised about 11 questions to be decided by the court, but all the 11 questions have not been answered by the Supreme Court of India. Still, a few cases have been kept pending, and whenever an appropriate forum anyone raises such questions, they shall be taken up, and the courts will adjudicate on those aspects. That is what the judgment talks about. So these are a few cases that are coming into my mind at this point of time, and all said and done, the Indian Constitution has been put to a lot of test pressure by the governments of the day at appropriate times. If you look at the number of amendments that have been taken up in the Indian Constitution, it is mind-boggling. So far, about 127 times, 127 amendments have been brought into the Indian Constitution. Several have been challenged, several of the amendments have been quashed, and some certain amendments stuck, and they changed the course of the Constitution. So when we look at amendments vis-a-vis the Constitution of India, the Constitution of India has been tortured, put out of shape because of the amendments brought in by the governments of the day. But if you look at American Constitution, which was adopted in the year 1776, since 1776, even after 250-300 years, it has undergone only amendments only 27 times. So that itself shows the robustness of the American Constitution when compared to our Indian Constitution. But all said and done, Indian Constitution is one of the comprehensive documents of governance that has been given to us by our forefathers, and it has got a way, a vision, and it is a living document. It is also said as a living document. So if the governments of the day abide by the Constitution, values, principles, spirit of the Constitution, and if they govern according to the established norms of the Constitution, then there will be no room for any friction among the institutions of the Constitution. But if the governments of the day turn to be dictatorial or have no respect for the constitutional processes, constitutional spirit, then there is friction between the institutions, like between executive on the one side, judiciary on the other side, legislative in between. So the conflict is bound to arise. In this context, the observations made by Chief Justice of India, Justice N.V. Ramana, yesterday, while addressing the Supreme Court Bar Association members at the Supreme Court lawns, he lamented that the quality of the judgments in this country has gone, the quality of laws made in this country have gone down. He wondered like why the lawmakers are passing legislations with so many loopholes and which are being challenged in the courts of law. Precious times of the court is being lost, litigation is pending, and it is doing no good to any part of the society. So he implored upon the legislators to be of value to the citizens and pass only such laws which they think are comprehensive and which are needed for the evolving society as such. So all these things need to be what we call reflected upon on this day. That's why I thought that probably I can share my mind with my friends, close friends, as to how my mind is thinking about these changes, particularly on the eve of Independence Day. So once again, before I conclude, I extend my 75th Independence Day greetings to all my friends and compatriots, and I wish you all the best. Thank you.